Obligations and Contracts. Obligations. Title 1. Obligations. Chapter 1. General Provisions. Article 1156. An obligation is a juridical necessity to give, to do, or not to do. Essential elements of an obligation. 1. Juridical tie or vinculum juris, efficient cause established by the sources of obligations. Article 1157. 2. Object, the prestation or conduct required, which in this case is to give, to do, or not to do. 3. Subject persons, the parties involved in an obligation, which consists of the active, obligee, creditor, and the passive, obligar, debtor. Includes both natural and juridical persons. Article 1157. Obligations arise from 1. Law. 2. Contracts. 3. Quasi-contracts. 4. Acts or omissions punished by law. And 5. Quasi-delicts. Sources of obligations. This enumeration is exclusive. No other sources of obligations are provided by the law. These sources are further discussed below. Article 1158. Obligations derived from law are not presumed. Only those expressly determined in this code or in special laws are demandable, and shall be regulated by the precepts of the law which establishes them, and as to what has not been foreseen, by the provisions of this book. Law not presumed does not depend upon the will of the parties, since this is imposed by the state and generally imbued with public policy consideration significance. Existing law enters into and forms part of a valid contract without need for the parties expressly making reference thereto. Article 1159. Obligations arising from contracts have the force of law between the contracting parties and should be complied with in good faith. Contracts. A contract involves two or more persons whereby a right is acquired by at least one of them to an act or acts, or to forbearance, on the part of the other or others, whichever stipulations, terms, and conditions are included in the contract, as long as they are not contrary to law, morals, good customs, and public policy or public order. Such contract is the law between the two parties. The court may interfere with a contract in the following cases. 1. When the court fixes a period upon a suspensive potestative condition imposed upon the fulfillment of the obligation. 2. When the court fixes a period when a debtor binds himself to pay when his/her means permit him/her to do so. 3. When the court equitably reduces the penalty when the principal obligation has been partially fulfilled by a debtor, or when the penalty is iniquitous or unconscionable. 4. When the court releases the obligar from an obligation that has become so difficult to be manifestly beyond the contemplation of the parties. Article 1160. Obligations derived from quasi-contracts shall be subject to the provisions of Chapter 1, Title 17, of this book. Quasi-contract. A quasi-contract is a juridical relation involving certain lawful, voluntary, and unilateral acts which prevent unjust enrichment at the expense of another. Article 1161. Civil obligations arising from criminal offenses shall be governed by the penal laws, subject to the provisions of Article 2177, and of the pertinent provisions of Chapter 2, Preliminary Title, on Human Relations, and of Title 18 of this book. Regulating damages. Felonies. Basis. Civil liability attaches to any person who may be found to be criminally liable. This source of obligations is guided by the following rules. A. The plaintiff shall not be entitled to recover damages twice for the same act or omission of the defendant, even though the negligence may constitute an entirely different cause of action. B. When the accused in a criminal prosecution is acquitted on the ground that his guilt has not been proved beyond reasonable doubt. A civil action of damages for the same act or omission may be instituted, requiring only a preponderance of evidence. See when a separate civil action is brought to demand civil liability arising from a criminal offense, and no criminal proceedings are instituted yet during the pendency of the civil case. A preponderance of evidence is sufficient to prove the act complained of. D. In cases of defamation, fraud, physical injuries, or when a member of a city or municipal police force fails to render aid or protection to any person in case of danger to life or property, or when any constitutional right under Article 32 is violated. The civil action shall proceed independently of the criminal action, requiring only a preponderance of evidence. Article 1162. Obligations derived from quasi-delicts shall be governed by the provisions of Chapter 2, Title 17 of this book, and by special laws. Quasi-delict a juridical relation where, if there is no existing pre-contractual relation between the parties, whoever by act or omission causes damage to another, there being no fault or negligence, is obliged to pay for the damage done.